My lords, I've had somewhat detailed discussions with senior or deputy director for the UK Border Forces that's behind me, Ms. Coops, at court. I have to clarify a number of points. Due to a somewhat inconsistent picture, somewhat in my instructions, I have arguably misled the Secretary of State's case. And that's mainly just on the nuances of the regulations in relation to before a journey and in relation to, I identified it was 2B3 about before any journey. Your Lordships will note that I said that that means at any point along the journey, and Your Lordship obviously I clarified that that didn't make sense on the regulations, because effectively that is the correct case on behalf of the Secretary of State, that it's before a journey at the point of loading. So the allegation, as I should have or ought to have outlined to the court, is effectively that the appellants failed to make a record at the point of loading effectively. So the journey started on the 21st, and if I can take you to the page references, but if we look at the actual trial bundle, you'll see at page 135, it says after loading, the driver made this checklist, but the Secretary of State's case is that what 2E2 establishes is that the owner hire must have their own checklist of the checks done before the journey. And I think that's more accords with where Your Lordship's observations and interjections were about my case before the lunch and adjournment.
You better just understand that, because that seems a radically different perspective. So your case is that there needed to be two checklists.
Yes, and that's why in the first appeal, you will see that His Honour Judge Owens identified that there's a delegation because the evidence identified from the appellant was that they delegated that task to the driver. So effectively, they on the basis of the incorrect checklists, the point was, well, all the checklists have been completed. But then at the appeal hearing, it was identified that these checklists at 136, 135 were, as I coined it, fraudulent. And the Secretary of State's case was based off the checklist presented at the time of the discovery of the clandestine entrants, which is the evidence contained in the witness statements on behalf of the respondent, which is page 273, which the first check there is on the 22nd, but the journey started on the 21st. That's when the loading happened. So it actually accords more. Now, I do apologise that there's been an inconsistent picture, but that is the Secretary of State's case.
What was the date? What was the date on which the incident happened?
So the incident occurred as per the page 137. So it was on the 24th.
So how does this fit with the particulars of the complaint in the notice, which was the checklist provided on the day of the incident, shows no checks within 24 hours of the incident?
So my instructions are that IS11 is, as Your Lordships have pointed out, somewhat inadequate in terms of pointing out the particulars of the breaches, because it doesn't. And it's misleading, and it's somewhat the point that I took incorrectly, that there should have been done 24 hours before based on what was actually presented in the checklists. That is not the Secretary of State's case. The company does their checklist before the very original journey sets off at the point of loading. So it's a red herring, effectively. It's wrong, it's a red herring.
So can we just follow it through? 273 is something that you got from the driver.
Yes.
So that obviously doesn't have anything after step 6.
No. And nothing before step 5.
Now, if we compare that to 135 and 137.
So 135 is the more prudent one, so to speak, or to the point, as the original journey started on the 21st at around 11 hours after loading.
So,
and that's when the company hire's obligation was to comply with 2E2 in terms of record keeping. and that record of the company hire ought to be with the driver in the vehicle as per 2E8.
So can I just follow that through? If we go on to 137, we get the equivalent of 273.
Yes.
And on the face of it, 273 is in part a copy of 137, is it? Or 137 is
Partially, yes.
So
Sorry, my lord.
I mean, looking at, it may have been changed a bit, but it does look as though it is actually a copy rather than something copied, if you see what I mean. It looks to be a photocopy. Or
Yes, it's not the original document, but what this effectively is 135, 36, and 37. They are what my learned friend's case was in the first appeal was as I coined it, the fraudulent document. The only document which was on the vehicle at the time was the one that appears at 273. So what must have happened, according to at least the position at the first appeal, was that the driver's then taken this and added to it all these entries which were not in the actual checklist presented to board.
so you take the document at 273 and copy it, do you?
Well, they take a photograph of it.
Yes, I see.
And
So
that's
the
what
driver keeps
Yes.
137.
There must have been at least 138 at the time of the stop.
It's as far as I'm aware, there's no copy of that. It may have been at the back of it. I can't obviously infer that or speculate, but it's not been presented through the evidence of the respondent's witness. So the only evidence it was at the front of, which is 137, replicated from 273. So 273 was the only header of the checklist.
I have to say, it'd be really odd if the driver started at 137. You'd have thought, I mean, why would he start at stop 5? Surely he would have done 1, 2, 3, 4, as we see at 135.
And it may well have been, but that point was conceded by the appellant at the first appeal, and they asked for their appeal to be dismissed. So they accepted the breaches as to inadequate record keeping or checks or otherwise. In relation to 2E2, to the driver, yes, to the driver, not the company. But the point the Secretary of State is making is at the point of loading. So this is where there's a change in goalposts, and of course I do apologise, but at the point of loading, that's when the owner hirer has delegated the task to the driver to conduct their checks as to loading. So that raises 2 points. The first is the driver and the company owner hire have 2 separate obligations, 2E2, 2E3. Secretary of State's case is that they normally would have their own checklists with the company provided to the driver, kept in the vehicle as per 2E8.
So can we just pause there? Are you suggesting that it's not good enough to keep one record?
It's twofold. In this case, there was no record done, no record presented of the checks done by the owner hirer.
I see that, but I just want to understand what the
And
Secretary of
the
State's
second
case is
point,
on the law. Is it the Secretary of State's case on the law that there have to be 2 checklists and it's not good enough for the driver to fill in one of them?
Effectively, yes. Because in this situation, there was no record done whatsoever.
No, well, I don't want to know. I mean, suppose the driver had kept one perfect checklist recording everything that happened. You'd still say the owner was in breach.
If the owner has provided a checklist of the checks they have done and signed off on, and it could be added to a driver checklist, it's whatever format it takes, it doesn't matter as long as the owner hirer has recorded that they have conducted the checks under 2E2.
The owner has to do the checks through a person,
Yes,
and a person has to do the record.
yes,
Why can't that be the driver?
it can be. But in this instance, the driver hasn't produced that checklist and it's under 2E8. There was a
Okay,
failure
well,
to provide that
very clear.
checklist.
What has been done? There must, I mean, at the very least, it seems to me, there must have been more documents than just 273?
So my instructions are these are the totality of the documents that were found by Border Force presented by the driver at the time.
I mean, it becomes more bizarre when we look at your IS-11 because that complains about the last 24 hours, not
Yes.
about what happened earlier.
Well, again, and as per my submissions before, that's a change position now. That is a red herring.
What's a
So
red herring? Sorry.
red herring in the sense that it says, as to liability, the fact it says 24 hours before isn't relevant to the checks that need to be conducted.
It's not. Forgive me. It can't be a red herring if it's the document on which you claim the penalty, and that's the basis. That's the basis on which you say that there's a notice. So where is there a valid notice? If that's as you use your phrase, a red herring, where is there a valid notice setting out the appellant's liability to a penalty?
So it states that there's a breach of 2E2. It incorrectly says that that should have been conducted 24 hours before. That there may be in instances, I know the regulation 2C3. 2C3 applies to where instances there are breaking an entry into the trailer. A warning can go off and notify the company hire, and they can notify the driver to make the checks. That usually comes across in electronic documentation or otherwise.
So
Well,
if you
in
were
this case-
now redrafting the particulars,
Yes.
so this notice contains notices of the breaches with particulars.
Yes.
So there's only one breach. How would you now propose? How should the particulars of breach in under number 10, paragraph 10, be phrased?
I don't have exact instructions on what it should say, but and from my position of reviewing the papers themselves,
Or make a stab at it. What
say
should it
that
sort of say?
the checklist provided on the day did not show, or no checklist was provided on the day of the stop demonstrating that 2E2 was complied with on the 21st of February at the point when the trailer was loaded and leaving the owner hire's yard.
Sorry.
Can you help me? Page 273 is a photograph which is currently in the bundle.
Yes.
Where do we find any description of what that is?
It's the vehicle checklist in terms of within witness statements.
Where is the evidence of what that is? Mr. Mills' statement starts at 172. Is that right?
Yes.
Now, as far as I can see, he doesn't refer to exhibiting any documents, does he?
Doesn't appear so. But it may be in.
The nearest you get is paragraph 11. Yeah, I'm not sure that helps you. So it says the driver did have a vehicle checklist with him, however, he had not completed it that day. So that doesn't confirm that 273 was the only page. What it seems to say is it hadn't been completed that day, which is what you find in the notice.
My lords, this is, I mean, with respect, is a somewhat moot point to what the appeal has ever been. The appeal initially was that the documents provided by the appellant, the falsified documents, were the ones provided by their driver, and that only changed very shortly around the date of the first appeal, and that was conceded that.
But I thought the falsification, well, until just now, I thought the falsification related to the final steps, final stops, not what had happened in the previous days.
Well, that document, my instructions are that document was never provided until after the notice of the penalty. Because that was obviously something which the
You mean
driver's then
you
gone
mean
off.
the equivalent of
till then.
135? 135 wasn't provided earlier. No, 133 wasn't provided earlier.
No.
But there doesn't seem to be any evidence to that effect. And I have to say, given the confusion, I wouldn't assume it.
at least it's a Secretary of State's case that there was nothing provided beforehand other than what's provided.
Where do we find that?
So within my pleaded arguments, or otherwise the case has always been there's no record.
Where's the evidence as to what was provided?
If I may just quickly go through the statement. There's the additional statement, of course, in relation to Ms. Thomason's first statement, but whether or not it's been referenced, there's the bundle of relevant documents which is produced. It's paragraph 5, introduces a number of documents.
And that's the photographs, includes the photographs we've got, does it? The photograph on 273.
Yes.
I haven't kept up. Where do you find this?
Paragraph 5 says AT1 bundle of relevant documents.
Sorry, which page are
I'm
you on?
also lost now. Where are we?
We're at the witness statement of Ms. Thomason, if that's correct.
Oh, I see,
pronunciation,
yes.
Page 178.
I see, yes.
Okay.
So,
Sorry.
And so is it Ms. Thompson who exhibits these documents?
Yes.
so what does she say about
They were
this?
acquired by Mr. Mills and then produced by, in terms of the consideration of the penalty itself and the decision the Secretary of State reached by Ms. Thomason.
The photograph on 273 is just the first page of the checklist, isn't it?
It appears to be, at least on this documentation,
Is
the only page of the vehicle checklist produced.
If I look at the later version of this at 137, there's a second page on 138. I'm assuming it goes down, doesn't it? So 138 follows on. So there should be a further page after 273.
Yeah.
Is that right? Have we got it? Is it there? Have I
No,
missed
that's
it?
what I'm making. That's the point I made earlier. Is there must have been at least that page.
But this is the point, at least in submissions, at least in evidence, that is the Secretary of State's position that was never the case put, that evidence was never provided by the driver. The only checklist provided was the one at 273.
Well, the successor page is the important page from the point of view of Regulation 2C3, because Regulation 2C3 is where the person responsible, about whether or not the person responsible knows or has reason to believe that a means of entry has been opened. And if you look at the checks on 138, that's where it talks about signs of unauthorized access. So that is the relevant page, isn't it? Those questions on 138 are questions which relate to 2C3.
Yes, so this was at the point where there was a misconstruction of a presentation of instructions incorrectly. The point is the company's obligation on a checklist is literally before the journey starts, and then the driver must keep that checklist on their person in the vehicle as per 2E8.
But forgive me, I'm sorry, can I just follow this through? Where did the page at 137 and 138 come from? Where did those pages come from?
That came as part of the appeal from the appellant.
Okay. So 138, the entries for 138, which follow on from 137, you're saying that the Secretary of State did not, the relevant, when 273 was completed,
Yes.
or produced to Border Force, or seen by Border Force,
Yes.
the follow-on pages weren't produced. Is that what you're saying?
Correct.
No, that's not right.
Well, is that what you're saying? Is it?
We can now see that paragraph 26 of Ms. Thomason's statement, page 183 of the bundle.
Yes,
The driver
so
was in possession of a security checklist. A copy of the first page of that checklist was supplied by officers at the time.
Yes.
So there was more.
But that's only in relation to these two checks. My instructions are that the previous pages, not obviously if we look again at the checks itself, my understanding, I based my instructions is that you have obviously the back of that page, you have the back of 273 isn't in the exhibits. I can't say for certain whether or not
So it's a
136
double-sided
was in that.
document, you think?
It must be based on what's here on relation to the photocopy presented by the appellants, but in relation to the previous checks from the 21st, those were not provided.
Well, where's
And
the
then-
evidence of that? It just doesn't seem to me that's before us or was before the judge.
So it's not in the exhibit which is produced by Ms Thompson, but the point is realistically from that there's no record of the owner hires doing their checks on their 2E2 before the journey. And this was the point about delegating that to the driver at the time of when there was loading and they were setting off.
Can I just pursue one or 2 points? I mean, one possibility on the face of it, on this thesis, is that the driver did make the record we see at 135, but it wasn't kept in the vehicle. Now, that wouldn't be the fault of the owner, would it?
So the argument would be, as my understanding is that yes, it would, because 2E8 requires that the checks done under 2E2 are kept in the vehicle.
And is that something that you can
handed to the
complain of under 2E2?
That's the driver obligation.
So it's the obligation on the owner hire to conduct 2E2 before the journey, and then once that's done, it's handed to the driver to keep on the vehicle as per 2E8. And
Well-
if they don't have that on the vehicle, the argument is that 2E2's been,
I follow,
2E2's been breached.
I follow that in the abstract, but that's not what you're alleging, as far as I know. And it isn't within the scope of 2E2, which is what you do allege.
So this is where the Secretary of State say that if 2E2 has been complied with by the owner hire, they complete a checklist either similar to this, which they sign off on, or their own individual one, that's then passed to the driver to keep on the vehicle. If that's not on the vehicle with the driver, then there's been a breach of 2E2.
Why? Because the owner has made the record, and the driver hasn't kept it on the vehicle. That seems to be a breach of 2E8, which is a driver responsibility, and in any event not alleged by you here.
So 2E2, well, it's been somewhat part of the submissions in the case, as in the transcript as well, that I raised it with the judge, that there's the obligation to keep 2E2 with the checklist from 2E2 on the owner hire with the driver in the vehicle.
And then can I just pursue one other point? If we look at 135, the DUD checklist, or partially DUD as they read checklist, this is part of what the driver apparently kept, or at any rate filled in at some point. And I just want to understand, suppose that the driver indeed kept this document correctly. Are you suggesting that this wouldn't do to satisfy the owner's obligations?
So yes, so this is the point which was raised at first appeal, that effectively, in this case, the owner hire delegated the 2E2 task to the driver, even on the face of 135, and that was the evidence from the first appellant's owner as well. It was essentially that they conducted these checks.
Yep. So what I'm trying, I thought you were saying a few minutes ago that there had to be 2 checklists. Now, when we look at 135, supposing that that had been filled out as we see here, would that have sufficed to satisfy the obligation in relation to recording of the owner and the obligation in relation to recording of the driver, or would they have needed to be a separate document?
So may I turn my back very, very briefly just to confirm that last point? I know I've made it already. Yes, that's right. So it can be either 2 checks, as I've said previously, or
As a
it can be
composite document.
it can be as per 135. But the Secretary of State's case is that 135 wasn't with the driver at the time.
Okay, so just so we're clear, and the statement on 183, forgive me, I forgot the name of the witness. Ms. Thompson, forgive me. Paragraph 26. PFO Billy Mills noted that the driver was in possession of a security checklist.
Yes,
A copy of the first page of that
Yes.
checklist was supplied by the officers of the port.
correct.
Is that page 273?
Yes, that's the first page. And this is the point by the Secretary of State, essentially, if we take that as the first page, that's in reference to, so if we look at 273, if it has been added to, that's been added to page 137, and if that's the first page,
Yes.
then
But it's
pages
not, forgive me,
136 and 135 couldn't have been provided with it.
surely the first page is 135, isn't it?
Yes, but it's not been provided. And that's why page 237 is referenced as the first page.
It seems that something was
Okay.
given to Mr. Mills, who gave it to officers at the port, who seems to have given it to somebody, which has ended up with Mr. Thomason making that statement. I mean, it's really very, very poor evidence, isn't it, as to what was given to us.
May I turn my back for just one moment, sorry?
Mr. Mills doesn't say anything.
So, my lord, my instructions are 273 was a picture taken by Mr. Mills. That picture is kept, the checklist goes back to the driver.
Yes.
That picture is then sent to the civil enforcement penalty team to then make their decision or otherwise as to notice of a penalty or whatnot. But this then evidence is exhibited by Ms. Thomason because this is the evidence she relied on and the basis of her decision to issue a penalty.
I mean, one trouble is that supposing that Mr. Mills was provided with a document, thought it hasn't been filled in for the last 24 hours, I better photograph that page. He might just have photographed that page and not worried about anything earlier because as far as he was concerned, that was in order.
It's with respect, it is a somewhat speculative point because it's not been raised by the appellants in the appeal.
But
The point
that's only
was
sort of
that there was
half
no
true, isn't it?
record
Because the
from-
appellants say, look, this is the document we were given by the driver. And the document they were given by the driver had all of it.
And of course, in the submission, they then said that they accepted this was a incorrect or fraudulent copy, and that the correct copy was 273, and the driver abandoned his appeal.
So let's just be clear. Were they, Mr. Clark may help us, were they accepting that that page was fraudulent or were they accepting that that was all that there was?
It may be an issue for Mr. Clark, but at least my understanding was the driver abandoned his appeal because he initially brought the appeal on the basis that this was the checklist he presented to Border Force. And of course, the Secretary of State through Border Force presented what they acquired, which was a 273,
Well, the
which does
photograph
not
shows
reflect.
that he hadn't completed stops 7 and 8. So one can see why he'd have had to accept that.
But it's obviously not the first page, is it? Mrs. Thomason's statement says it's the first page.
Yes.
But it's obviously not the first page because it refers to stops 5 and 6. So there must have been somebody with stops 1, 2, 3, and 4.
Again, it's a somewhat speculative point. That evidence has not been presented by the appellant in statements or otherwise. The Secretary's position is that this was the only checklist presented, and that was the first page of the checklist.
It's your notice of penalty that refers to the previous 24 hours. So I think if the burden's anywhere, if you now want to make points about the 21st.
So again, this is where there's somewhat confusion of the submissions before lunch occurred. The case has always been that the company hires never presented a record of under 2E2. So that's always been the firm case, and misunderstanding arose as to my
We
submissions
better ask
before.
Mr. Clark what his position is. I'm just looking back at the evidence from the appellant. If we look, say, at page 80 of the first bundle, beginning at 79. Paragraph 15, reference to the checklist. Then paragraph 16 conducted 3 checks on the 21st of February, 3 checks on the 22nd of February, and so on. And this must be by reference to the document 135, 137. So at that stage, the appellant is proceeding on the basis that those checks took place and were recorded. Mr. Clark, I won't ask you to respond in any detail. What is the punchline on your position?
I choose my words carefully. It is said, this is a point not raised by the appellant in the appeal, because we had no idea that this was, in fact, the Secretary of State's claim. This is completely new to us. As new as the claim advanced by the Secretary of State this morning, vis-à-vis Regulation 2B2 and the duty to record a non-event, if I can put it that way. That's my first point. My second point is this. Our case has always been that the company complied with the requirements placed upon them, and that the checklist originally provided to Border Force consisted of more than one page. It was retained by the driver and then fraudulently changed later on. And the fact that the Border Force officer took a photograph just of the page that he at the time concluded was relevant to his determination is nothing to the point in this appeal or the appeal below. Does that deal with the question?
That does, thank you very much.
Can I just ask, does your evidence, did you file evidence in response to what is said in paragraph 26 of Ms Thomason's statement?
Can I just turn up paragraph 26, please?
Did you file a statement?
It's not my computer. I'm going to have to give the machine.
Oh, this is the statement of Mr.
Nestianu.
Yes.
I think there was a second statement, but I haven't
There were
got
two
it.
statements. Were there two statements from this? Yes, there were two statements.
There were.
Yes, because criticism about these statements were made in a different respect.
And the second one doesn't seem to be in the bundle.
No. The second one is the one that says, and I paraphrase, "My goodness, our driver's a fraudster."
And unless you tell me I'm missing it, it doesn't seem to be in the bundle.
What's this? Okay, have we got the second statement?
And if it isn't in the bundle, we better definitely have it.
If it assists, I have an untouched copy of it.
Oh,
electronically.
perfect. Can I see it, please?
Email you.
My only friend has a copy. If we can't find one in time, he's
Yeah.
emailing. Well, can you email it to Ms. Dewar? You're online. Okay, I have it. Where does it appear in the bundle?
I don't think it's.
Or is this something?
This is. Mr. Howard says he's just emailed it to me. When it comes through, you can open it from there.
Let me back to my just now. That's great. Okay. I have it, but it's the original version from my instructing solicitor's file. It is 3 pages. I think the best thing to do is email it to your
Yes, please.
clerk.
Is there anything we need to know about it
I'm
now?
just going to whip through it if I may.
Yes, please.
There's the usual citations at the top. It declares it to be an addendum statement following the service of the respondent's evidence. I've become aware of the checklist provided to Border Force. This is the checklist that has been submitted by the respondent as presented by the driver at the stop. this checklist is inconsistent with the one supplied by me, the statement writer, to the driver. It then talks about the bringing of the appeals. It talks about the driver's history with the company. It says on 23rd of February the vehicle was stopped once Port of Calais had identified clandestine entrants, but whilst the driver was stopped he informed me there had been discovery of entrants. He also informed me that he had completed a checklist and this had been provided to Border Force. The checklist provided following the journey. Driver confirmed that this was the checklist that he had provided. I saw no reason to disbelieve it. This is my understanding that the checklist I supplied with my first statement, which was the exact checklist provided by the driver. I was made aware only following the respondent's evidence that the checklist provided to Border Force was incomplete. It's clear to me now the driver added further information following the stop and then presented this as his checklist to me. And then there's a request that the driver's appeal be dismissed.
Yes, I see.
So from that I would submit there was a complete checklist which was then added to. Thank you. Can you?
So could that please be emailed?
That's been done as we speak.
So, Mr. Howard, if you obviously need to move on to the other points of the case. The Secretary of State's case, as we should understand it, is that the deficiency, so far as the owner is concerned, is that there is no record of the checks being carried out before the original journey began.
Yes.
Can I ask you this in relation to that? The owners are a Romanian company, and this was a journey that started in Bologna. I'm presuming in the way much international haulage is conducted, very often the only representative of the owner who is going to be present at the start of a journey will be the driver. Do you agree?
In the vehicle, it could be, yes.
Cool. Even if a vehicle is going to and from the owner's premises,
Yes.
in fact won't be the case, but even if it
Yes.
were, one of those two legs is going to be at a distant location.
Yes.
And the only representative of the owner there will be the driver. So the driver fills in the checklist on behalf of the owner at that point, does he not?
So my understanding is that the checklist is to be completed at the very beginning of the journey in relation to, as it outlines in 2.2, as the checks prescribed. So that could be in the owner hires yard before the vehicle leaves whatsoever with a load, presumably with a load, or it may go to the point where it collects the load and has the trailer put on, and then it's from that point. So yes, there is to some extent possibility where that is delegated to the driver, the task of the company hire to complete that checklist and say,
Well, that's going
this
to
is
be the
before
case
the
in the
journey.
vast majority of journeys are going to start at a location where the vehicle picks up the consignment, and at that location, the driver with his vehicle will be the only representative of the owner there. Must be right.
Must be.
All haulage companies, vast, are going to collect goods from A and take them to B. They're not going to take them from the haulage company's depot, are they?
And so most of the time,
Just cautious to
the
make
checklist
points.
is going to be completed by the driver. And he's doing it insofar as it's the owner's responsibility, it is the driver is doing it on behalf of the owner. Yes. And it doesn't make sense in that context, does it, for him to complete two different checklists?
As I say, it can be in the same checklist.
He can complete one checklist, and insofar as he's completing so far as they are owner's obligations,
Yes.
he's completing it on behalf of the owner. So far as it's a driver's obligation,
Yes.
he's doing it on his own behalf.
And that accords with what Mr. Nestinanu says, the appellant owner, in his statement, he said, because he doesn't say that it was done by him,
No.
at the yard, which accords with your lordship's hypothesis or presented example. And what he says in his statement, which mirrors the judgment of His Honour Judge Owens, was that this was a task delegated to the driver who didn't have training as to completing checklists. Otherwise, that's a separate issue, and I'll get on to that.
Again, I think
But
delegation is the wrong term.
I'm simply mirroring what was used in the judgment below.
It's not vicarious liability. It's not delegation. It is the owner's obligation,
Yes.
which it has to perform through a human being, and it performs it through its servant or agent, who is
Yes.
the driver.
That's exactly the point, yes.
But there's no, so we can do away with the 2 checklist points.
Yes.
Can we
I was simply me presenting it if there is a difference
So-
from the driver.
So as I understand it, on the question of failure to comply with the regulations, it really all turns on whether 135 existed.
At the point Mr. Mills, it was Mr. Mills, stopped the vehicle.
Yes.
Yes, effectively, but the Secretary of State's case has been that what is presented
Well-
is the first page of the checklist, and that what has now been presented to the appellant's case wasn't there.
Forgive me, but your case as presented on the notice of liability was that the checks hadn't been carried out within 24 hours prior to the incident.
Correct.
You've now stepped back from that and said it wasn't carried out before the vehicle left Bologna.
Yes, my argument, or at least my submission on that, is that it's a separate issue as the evidence gathering. It's obviously the Secretary of State's case is based on here's the evidence we gathered at the time. The statement of Ms. Thomas says this is the first page. Obviously, the correctness of the IS-11 on first appeal before His Honour Judge Owens, of course it may be incorrect, but it's a de novo hearing. And the point being is that the Honour Judge could reassess all the issues afresh at that point in time.
But it's obviously not the first page, is it? It's not, it can't, the first page, as at 135, which you say is, as I understand, you say that's a fake first page. Is that your case?
But there's no evidence to suggest that
The
what
first
is
pa-
then being presented at 135.
All the information, sorry, I interrupted you. I'm sorry, no, I should have interrupted you.
My apologies.
The first page would be the page which obviously includes the company name, the driver's name, the date, the vehicle number, the trailer number, etc., and the place where it was loaded, Bologna and then Verona. Is that right? Yes. So all that is on 135, but none of it is on 273.
And there's no evidence from the appellant, Mr. Nestanyahu, in either of his 2 statements to say that the checklist started 135 and what Border Force are relying on, the subsequent pages on 273 is wrong. Because the evidence before the court at that time was that was the first page.
Why would they produce that evidence when the charge against them was in relation to the previous 24 hours?
The statement stated, the statement presented by the respondent clarified, and so did the submissions, that there was no record presented whatsoever from.
But on your case as presented, as your case on the 24 hours point, the previous
Yes.
24 hours point, 135 is irrelevant. It's only relevant on the way you're now putting the case, which is that it was the error was at the outset.
That was how effectively the case was put at first appeal as well. And it's in my skeleton argument. I alluded to it, paragraph 8 as well.
Sorry, the new skeleton argument, or the
Yeah,
skeleton argument for
new
the.
skeleton argument, and as well as the original skeleton argument saying there was no record by the appellant hire company. I mentioned in paragraph 8, the response case is that the failure to make records in a checklist is the triggering factor breaches regulation 2E, and that's following on from what the appellant put their case as. Obviously, that's just me summarising that, but the case is put as per Ms. Thompson's statement. It is put as for His Honour Judge Owens that there's been no record.
Can I ask you this? You can look at page 273, you can look at the entries for stops 5 and 6. And you can see that those have been completed by the time Mr. Mills came to see this document. Now, as counsel representing the Secretary of State and those representing the Secretary of State behind you, can you really stand there and say that page 135 wasn't also in existence at that time? Because I have to say, sitting here looking at it with hindsight, it seems absolutely obvious to me that 135 was in existence at the time, and that your evidence adduced doesn't really go very far to refuting that.
My lord, last instructions on this point, was there any other pages? It's a point raised by those who sit behind me immediately. There is no other evidence of the checklist from what is put at 273. That has been the case before the first appeal court. There's never been any position clarified or argued differently by the appellant. It's only raised now, obviously, in relation to what's here.
But you've got to be realistic here, haven't we? All that we've got is a photograph of one page. You've seen now seen 135. The evidence from the Secretary of State, Mr. Mills, who's the person who actually dealt with it, doesn't say anything about the checklist at all. And Ms. Thomason is reciting multiple hearsay, and your only evidence supports that position is her one reference to them saying it was the first page. That's it.
And the Secretary of State can only, in presenting the case at the first appeal, can only go off the evidence before the court at the time, and indeed the second statement from Mr.
One would
Nestor.
expect the Secretary of State to take a realistic approach, particularly dealing with the imposition of penalties, where it does look as though the documentation is something of a mess. And I have to say, my current view is that the position of the Secretary of State that there was no page 135 is not realistic.
My Lord, there's no evidence to suggest that there are previous pages than other 273.
There's page 135.
This Secretary of State's case has been that this is fraudulent.
Which is an evidence before us, and which is plainly on its face a predecessor page to 273.
Forgive me for interrupting. I may be able to assist on this point. I'm looking at paragraph 26 of the statement of Ms. Thomason.
Yes.
PFO Billy Mills noted that the driver was in possession of the security checklist. A copy of the first page of that checklist.
The trouble is, what does the first page mean?
I mean, page one. This is clearly not page one.
What we're well, that's the point we're putting. Lord Justice now been putting to Mr. Howard different perspectives. I mean, our point. The point is that all the information you'd expect to be on page one isn't there.
Yeah. If we take yes,
What we've got looks like a follow-on page because it refers to stops 5 and 6.
yes, and obviously, I mean, I plainly see your lordship's argument. I mean, it's completely fair enough. If that was the checklist and that was page one, my point is you would expect to see that at 273. But the Secretary of State's case is that was not provided, and therefore
just
the
for
first
complete-
page is only at 273.
For completeness, can we go to 269 just in case we can get anything out of it? Which I suspect we can't. 268. So this is Mr. Mills' notebook, I think. And in the top half of 268, you see the page that possibly is relevant, where I think it says driver had no written instructions but security checklist. So is this a security checklist?
Yes, at 273 would be the security checklist.
Yes,
Those
or
are
it could
our
be that
instructions.
that's the page that mattered to him because it was incomplete.
I mean, those matters realistically should have been asked of Mr. Mills in cross-examination or whether they attended the first appeal. But of course, we don't have that evidence. The height of the evidence is first page provided, and that's a 273. I cannot take that point any further.
It may be, given the deficiencies in the evidence, that one focuses on what you alleged in your notice. You alleged in your notice that there was a breach of 2E2 because the checklist hadn't been completed in the last 24 hours. It turns out that failure to complete it in the last 24 hours wouldn't involve a breach by the company, therefore no breach. And that's that. I mean, it's not that in terms of that isn't the end of the appeal, but maybe that's that in terms of the allegation of failure to comply with 2E2.
I understand where your lordship's coming from, but I can always obviously only relay the Secretary of State's case as to what they had in front of them has been included in the exhibits.
Mr. Mills knew that it was stated that the vehicle had come from Bologna, didn't he?
I believe so.
It's in
mentioned
his
it.
note. Place of loading, somewhere Bologna.
How would you have known that?
Sorry?
How would you have known that?
Because my
Well-
understanding is he's a discussion with the driver.
So,
That's speculation.
I mean, isn't that further, a further clue that, whatever it is, 273 isn't the first page? That he was told that it set off from Bologna?
Sorry, my lord. I'm grateful to those who instruct me who have pointed out that there's other exhibits produced by Mr. Mills,
Okay.
which were referenced by Ms. Thompson in her statement that demonstrate the origin journey of the driver. It's you'll see that she obviously references Mr. Mills' his notepad and notebook from 267, and you'll see before 273 documentation.
What's that? 272?
So yes, from 270 onwards. 272.
This is a CMR, isn't it?
Yes.
Well, that refers to Bologna at the top. And the first, which is a commercial document, so you want to be more familiar with this than I am. But this, it looks as though the location of, it confirms that that Bologna was where it started, the journey started. Is your point from those behind you that what's said in the notebook at 268 is from that document, rather than from anything Mr.
That's again, Secretary of State's cases. That's all the evidence that was provided, and that would be where an indication of Bologna's reference in the CMR, and it correlates to what's in the notepad as well.
And is there, yeah, right. But he knew that it started from Bologna. I mean, isn't that again further evidence that 273 isn't the first page?
And I know the observation your lordship is making, but again, I'm some pains to stress that this is the height of the evidence before Mr. Mills.
Well, the focus was all on what happened after this, because if we compare with there's a blatant. I say blatant. Event, nothing's blatant in this case. But if you look at in one sense, but if you look at 137. Someone, you're going to say it's the driver, the assumption is the driver, has not only added stop 7 and stop 8, but has also made some change to the date in stop 6. Yeah. He's written over the first two.
It's been added to. I mean, it's the height of the appellant.
So the whole focus of your case was what happened after this, wasn't it? What happened after the obvious additions of step 7, step 8.
It's almost, my lord, the point I actually made before lunch and adjournment was it's almost parallel to this point. The Secretary of State looked at this and said, there's no evidence of the 2E2 checks before the journey. Therefore, they've breached 2E2.
That's not how it was put in the notice. The notice of penalty was
Yes.
focused on the last 24 hours, which is
Yes.
stop 7 and stop 8, isn't it?
Yes, but of course, it's not a public law hearing in the sense that whether or not the IS11 is incorrect or not, and then that undermines the decision itself. It's the point being, it's a de novo hearing. The facts before His Honour Judge Owens were fresh. He can take any consideration of any point for him at that time. The issue was not raised. The point of the Secretary of State at that hearing was this is the only checklist provided that was within His Honour Judge Owen's determination, and that the point being they've breached 2E2 because they've not provided a record of the checks done.
Just before we go on to the other points,
At 135.
going back to paragraph 10 of Mr. Mills, what he says in paragraph 10 is, the driver confirmed with me that his last stopping place was the 23rd of February 1400 at a particular service station and departed at 1445. The driver did have a vehicle checklist with him, however, he had not completed it that day. So that's all consistent with the Mr. Mills thinking, look, I know there was a stop. The checklist should have been completed and it's not there. Therefore, I'll photograph the page of the checklist which shows that he didn't record that. Yeah.
I mean, I perfectly understand where your lordship's coming from,
Yes.
but of course I've relayed the position on behalf of the Secretary of State. I can't take it any higher than that. I can't read behind
No,
the
no.
case as it was put in the first appeal. That is the height of the Secretary of State's case as to the breach of 2E2.
Yes.
Could I be forgiven for interrupting? And I really don't want to make a habit of it, but I'd rather this point didn't reel away. It's been said on a number of occasions now by my learned friend that a particular point was not taken below. The reason
I think, Mr. Clark, you can wait for your reply for this, probably.
Okay.
So, Mr. Howarth, we've been through compliance, obviously,
Yes.
at some length. So,
My remaining
partic-
points are somewhat more brief.
particularly, supposing that the judge was mistaken and thinking there was a breach of 2E2, what happens then?
If the judge was wrong about liability on 2E2,
Seems quite likely that we might reach that conclusion.
it's somewhat of a domino effect to the other grounds, other than to say there are some incorrect points raised within the other grounds which I have responded to within my skeleton argument. There's reference within the penalty code itself as to scenarios and how there's liability apportioned to the company in circumstances where they're liable to a penalty because of the fact that the checklist wasn't completed. That's within the scenarios. That's obviously a point which I responded to in ground 4 of my submissions. But when I was introducing my submissions to your lordships, the points we have now just analysed in detail was my first point, which responds effectively to ground 1. I have made the point already about my second point was the definition of responsible person, persons responsible. It's the same meaning. My respectful submission, that's the Secretary of State's case. The third point that was raising in relation to ground 2, which is the system in place or reliance on the old defence. It's almost as in, and your lordships alluded to this before the lunchtime adjournment, that it's almost the system in place now has given us removed that defence, makes the liability somewhat stricter in terms of the tasks of the driver and the owner company. But the argument raised by my learned friend was that the learned judge incorrectly relied on the defence which has been repealed. My respectful submission is that ground isn't made out because it wasn't material to the overall decision in the sense that he clarified within his judgment, and that's clearly seen within his determinations. To page 102, it's paragraphs 56 to 57 and 61. The learned judge clearly outlines that the defence has been repealed. And he goes through that. My point being, there's no arguable case. There's no arguable case at ground 2. The judge referred to the lack of adequate systems or otherwise when making discussions as to the level of penalty and the fact that there is, in his words, delegation of the task of compliance of 2E2 on the driver, and that was the point he was seeking to make. Fourth point submission, very briefly, was there's analogies made in relation to Honour Judge Coe's judgment as referred to in the skeleton arguments, and again reference to the smuggling provisions. Those, in my respective submission, aren't helpful because of course it's not the matter an issue before the court. That's simply the only point I'd make in relation to that. In terms of the penalty code itself, this is the point raised as to discretion. There is a discretion on the Secretary of State as to whether or not they should exercise their discretion as to make a penalty. It says may within the statute. If you look at the penalty code itself, and it's within the authorities bundle,
Yes.
again, it makes numerous references to that discretion. In my respectful submission, you have it at page 81 of the authorities bundle. So the point is made that there's nothing in this that says you have the word nothing as a penalty, but then you have scenario number 1 under section 32, where it's clear there that the vehicle owner receives a £0 penalty, and that was in reference to the reductions that can be applied as to the level of penalty. But that's taken from further back within the authorities bundle, page 71.
Sorry, can we understand scenario one? Scenario one is the owner's a member of the accredited scheme.
It was simply, the point was made that there's nothing in the code that says no penalty is made. And it's clear from the scenarios that there are circumstances where no penalty is made. The point being that there is a discretion before the Secretary of State, rightly so, not just in the statute, but also within this penalty code, which is, it details that discretion in the introduction itself, which is at page 76.
And sorry, just before we go there, so
Yes.
this is a case, hypothetically, where the
Yes.
driver, the owner isn't penalised at all because they qualify for the 50% discount by
50
being
plus
accredited,
50.
and they qualify for another 50% because
Yes.
they complied.
And then it says, had it not been accredited, then they would have received a penalty of £24,000 for a clandestine
Yes.
entrance. I'm simply just responding to these points raised, to clarify the Secretary of State's position, because you have page 76 of the authorities bundle. It outlines, however, if a person is unable to show a defence against the imposition of a penalty, then the Secretary of State may require that person to pay a penalty. That again is reference to the discretion within the penalty code.
So if we conclude that the judge was wrong to find that there had been a relevant breach by the appellants of their obligations as far as record keeping is concerned, in those circumstances, there would be, well, what do you say? What should we then do? What do you say we should do?
If you outline that there's
If
no,
we conclude that the judge was wrong in his conclusion about record keeping, in the light of the discussion we've had, obviously we have to think about your submission, but if we're against you on that record keeping point, what happens next? Where do we go?
may I just turn my back very briefly just to
Yes.
finalise the submission? I'm grateful, my lords. Yes, so in those circumstances, they still get a penalty
Yes.
because the driver has breached, and that's seen within the scenario itself.
That would be a small company discount, which the judge, effectively, it would be the penalty would be as per the judgment, except you take out, you add in a 50% discount.
Yes, because they've ensured compliance with the
There would be
regulations.
6,000 less 50%,
Yes.
3,000 times 8.
Yes.
Is that right? I thought we got it. The total penalty had come down to 36,000, so presumably it would be halved to 18,000.
No, my maths has gone wrong.
I think
So
it's gone down to 4,500 per
Three.
entrant, hasn't it?
Oh yes, that's right. 25% discount. Yes. So there's 50% off that, is it?
So it's 20. You do it as per the
Yes.
penalty code. So there would be 50% reduction just for steps ensuring compliance with the regulations. Wouldn't be 50% because they're not accredited.
No.
And then you make any assessment as to means at that point. And make
6,000
any,
starting point.
Yes.
25% deduction.
yes.
50% of that. Is that
Sorry,
right?
50% first, then the means.
It
So
shouldn't
if
make
you
any
look at-
difference which order you do
I'm only
apply the
following.
functions.
So if you look at page 78 of the authorities bundle,
Yes.
apologies, my lord, it relates to section 32. I'm simply just following what's on that.
Yes,
So
no,
it's
quite.
maximum level, starting point, apply discount, discusses joint liability, and then part 3 is the means testing.
Okay. So but the Lord's right. It's 18,000 either way.
Yes.
The bottom.
I do apologise.
I mean, tip from him and from you, but I wouldn't trust my own maths, as you can tell. It might be said by Mr. Clark, he hasn't addressed us on this yet, I don't think, that we should in some way exercise the discretion which is there in the statute. What would you say about that? He would say his clients were completely blameless on if we conclude that there was no mistake on the record keeping. So therefore, that we should take that into account, and he probably would like us to say naught.
Well, again, it's completely a matter for your lordships. It was my response on ground 5 that His Honour Judge Owens did consider discretion in his judgment as per Bowl. It's the last consideration, effectively.
But it wouldn't be completely a matter for us, would it? Because if the judge has exercised discretion, we could only interfere with that on the very limited basis upon which
Yes.
we would exercise discretion.
So if I could take then your lordships to the use of discretion in this case, which is page 105 of the core bond for the
In his judgment.
in his judgment. It's
Unless one were to say that because he erred
On the record keeping.
on the record keeping,
That
effectively
violates his
we have
discretion.
to exercise discretion. Well, that's where we could have to do it.
Because they would, on Mr. Clark's case, they are blameless, whereas under the judge's supposition, they weren't.
Yes, and well, how his honour considered it is he considered the breach first, then he considered the adequacy of his instructions to the driver in that delegated task, as he said. He then considers system and training, which is the old defence, and how that's applicable and not. And then he considers use of discretion, and thereafter considers the level of penalty. And I think that's in line with the steps identified in Bowl. It's the liability, discretion, and then level of penalty.
Well, the first part of page 105, 77 to 80, is all about the record keeping, and he concludes in 80 that there's been a generous substantial breach. He then goes on in 81 to make a point about instruction of the driver.
Yes.
So you would say, presumably, that when considering anything about discretion, we should also take into account 81,
Yes.
the findings on which were not affected,
Yes.
would not be affected by any different view we came to about record keeping.
So it's the point I've made in my submissions that the issue as to system of training, the old defence as applicable in this case, it may well be a very important consideration as to the use of discretion, and that seems to be where His Honour Judge Owens applied that level or adequacy of training. My respectful submission is that's correct. That's lawful in the circumstances in terms of the steps set in Bowl. That's the correct pronunciation. So that would be my response on that.
If we took the approach of saying that the owners had done everything they could do to comply with the regulation, and therefore we should exercise a discretion not to impose any penalty, we'd effectively be rewriting the whole scheme. Because the scheme expressly provides that if you've complied with the regulations, you get a 50% discount. So if we give a 100% discount for that factor, then
You would be rewriting it. Yes.
you would write it. And also, you wouldn't just be giving a reduction, which is what the statute and the regulations and the code said. You'd be giving a complete waiver.
Yes. So obviously the penalty code doesn't act as a fetter of discretion for the Secretary of State, and it shouldn't do. But the point I was seeking to make in my submissions was that when you reach the stage of looking at the penalty code, you've effectively decided on your discretion to issue a penalty on liability or otherwise, because the point made from Bowl is it's liability first, exercise of discretion second, and then level of penalty.
Besides that, the way it works is if clandestine entrants get in through your vehicle, you are liable to be penalised.
Yes.
And then there are reductions if you have done various things.
Or otherwise, yes.
But it's not a matter of saying we won't impose a penalty if you've done these things. It's a matter of your starting point is you are penalised. Or you may be penalised.
Yes.
Yes.
And the discretion comes in up before the penalty deductions.
Yes.
That's slightly counterintuitive, isn't it? You'd think you do the formal bit first, and then you'd look at it in the round to say whether in exercise your discretion you should knock a bit more off or knock a lot off.
May present an opportunity for your lordships to set guidance on that point, because
I mean, it may not matter which order you approach things in, but just looking at the statute, this is section 35A, isn't it?
Yeah.
coins it in such a way, or phrases it, sorry, in such a way that says may. So you could read it as saying, well, there's a discretion to begin with. And then once, as the next steps, a bowl will come in, you can have discretion before or after, it seems, and even during the consideration of the penalty code, because it phrases it as may.
And with 35A, you get to the point where it says there's going to be a rehearing and is to be determined having regard to the code of practice
Yes.
and any other matters which the court thinks relevant. Which rather suggests that both into when certainly when you're thinking about whether to impose a penalty at all, the code of practice wouldn't seem to come in.
No.
But other matters might
Yes.
come in. And when you decide that there ought to be some penalty, you have regard to all of it.
Yes. May I turn my back just very briefly?
That's what it says. It doesn't think it makes sense. Surely you take anyway.
Is it, sorry, I think the point that was being raised with me was that the Secretary of State considers the discretion to begin with. But of course you don't have that in a statement before you. I don't wish to
No,
give evidence, but
I
it
have seen-
coincides with the wording, at least of section 32.
Yes.
That discretion is considered to begin with. So, my lords, I made my fifth point, which responds effectively to grounds 4 and 5 of the appeal. The last point that I just wish to make was that in terms of actually acquiring a credit under being added to the accreditation scheme, it is free to join. And those are my instructions, that there's no charge to join the accreditation scheme, but to be accredited, there are a number of loopholes, which is considered by His Honour Judge Owens in his decision, paragraphs 85 and 86, at page 106 of the appeal bundle. Again, my submission is there's no identifiable error law with those considerations within the determination at the first appeal. May I turn back very briefly in case there's any other issues? I'm grateful, my lords. Can I assist you any further?
No, thanks. No, thank you very much, Mr. Howard. Mr. Clark.
Can I please respectfully deal with the last substantive point first, which was, my lords, where do we go from here if we find the judge fell into error? And whilst repetition doesn't really serve any useful purpose, I'm afraid I'm going to repeat myself on this point. The starting point is section 32.2. That's the primary legislation. Section 32.2 contains a discretion by use of the word may. And if that's the starting point, then it must be right that when considering whether to impose a penalty or not, that is the first step to be taken. The may imports into section 32.2 I submit, very wide discretion that the Secretary of State and or any learned judge considering a first instance appeal can take into account matters which the court or the Secretary of State feel are proper matters to take into account. And by definition, that must include whether or not a responsible person is, my word, nobody else, is innocent of any misconduct or failure. The fact that that innocence may then be repeated in a code of practice to be taken into account once it's been determined that a penalty is to be issued is nothing to the point in the exercise of the discretion under section 32.2.
Oh, but it's not just in the code of practice, is it? It's also in the statute.
Again, we're at may, but the statute, when you deal with section 35, that's to deal with the process on appeal.
Not section 35, it's in section 32.
Forgive me.
It's in section 32, 2B.
before making any regulations under subsection 2C, that is the carriage liability regulation.
2B, the Secretary of State
Oh,
may
forgive me, I thought you
reduce
said
the amount
2E.
of the penalty if the responsible person can show they took the action specified in regulations under subsection 2C.
Yes, and in my respectful submission, that follows on, that comes after the judge or the Secretary of State has considered whether or not to impose a penalty under section 32.2 in the first place, because the words of section 32.2 of itself imports the discretion. Section 32.2b only comes into a place after it has been decided.
You can't read too much into the word may in 32.2, can you? Because the opposite of may is must, and you're just not going to impose a positive obligation on the Secretary of State to impose a penalty. Because, for example, the Secretary of State will not know about everybody who is responsible for a clandestine entrant.
No, and so
But this is the wording you'd expect, where there's a power to do it.
well, two points. First of all, your second point, yes, I agree, the Secretary of State may not know, and so the Secretary of State may impose a penalty, and then the recipient of the penalty may then bring matters to the Secretary of State's notice, which forces the Secretary of State to revisit the original decision to impose a penalty, and likewise they may appeal to the first instance court, and the same will apply. But the second point, and I submit is slightly more forceful, is that this court in Bolly found that may imported a discretion not to impose a penalty.
Well, there undoubtedly is a discretion there, but the extent of that discretion must be informed, A, by the purpose of the statute.
I don't disagree with that.
Which is to prevent clandestine
That must be right.
entrance. And secondly, by the fact that the Act and the regulations and the code specifically provides a reduction in the circumstances which you are now praying in aid to invoke the discretion not to impose a penalty. And it seems to me that would be take something out of the ordinary for the Secretary of State to decide not to impose a penalty because of the factor which under the scheme only entitled you to a reduction.
Well, if I don't have it my way, if I can put it like that, then when is the penalty not going to be imposed? And I take my Lord's point about truly exceptional, but the reality is...
Well, not truly exceptional, just something out of the ordinary.
Well,
What is that? I mean, let's imagine up and down the country there are people who fall foul of the clandestine entrance up and down the world, in fact, not just the country, and are penalised, and a number of them may be able to get reductions because they comply with the regulations. Well, what is there? There must be something, surely, beyond the mere fact that they have qualified for that reduction, which would lead to the Secretary of State imposing no penalty at all for that reason.
I have to confess, I don't want to speculate, but I am struggling to identify any such feature that might come into play beyond a haulier, an owner hirer who has done everything which the regulations require of it. What feature beyond that, I rhetorically ask, can figure...
They could have gone well beyond complying with the regulations.
Either we complied with the regulations or we didn't. And if we did, you can't, forgive me for putting it like this, you can't comply with the regulations over and beyond that which the law requires you to do so.
Why not? You might have got particularly strong locks, you might have got particularly secure trailers, you might have got you might have hired security guards to accompany the vehicle. You might have them armed with machine guns and whatever.
Can I pause you there,
But
my Lord, please?
nevertheless, somebody's managed to get on board.
Whilst this is said in submissions, respectfully, can I quote you on that? Next time I appear in front of a first instance judge, and I only say so half humorously, because when you are appearing at first instance and under my lord's contention you are seeking to persuade a first instance judge that the case you are advancing takes you above, well above the position that the regulations require, and I start talking to the judge about extra special locks and I don't know, machine gun guards and the like, I rather suspect that little truck will be had, because the requirements, if one reads into the regulations, is that there must be effective security, there must be proper locks, there must be a proper...
Nobody's suggesting here that it will be very easy to persuade the Secretary of State not to exercise the discretion to impose a penalty, because the whole scheme is based upon the fact that if there is an entrant, a clandestine entrant, the penalty will be imposed.
Well, that's my problem. Forgive me for putting it like
That's
that.
the scheme. That's the statute.
It's not the scheme, respectfully, on a bare reading of Section 32. And I suspect we're not going to agree with it.
Well, it's not a scheme that seems to have been applied by the judge.
No.
And the judge took two, if you look at page 105, the two factors he took into account on discretion. First of all, the culpability in respect of record keeping, which, assuming you win so far, goes. But also the matters in paragraph 81.
Yes.
Now, do you say that he was not entitled? I'm not sure that has features in your appeal so far. Do you say that he was wrong to take those factors into account?
I do, and it does figure in my grounds of appeal.
I'm sorry that I misread it.
I can't remember which ground. I complain that the judge took into consideration matters which related to the old scheme, being training.
Well, why doesn't that relate to the new scheme?
You'll have to ask Parliament. Forgive me.
But if Section 35A says as it does, you can take into account matters you think relevant. Why wasn't the judge entitled to think that this was relevant?
I say because it was a feature of the old scheme, not the new scheme. The new scheme makes no noise at all about any training requirements or any monitoring requirements or a number of other things which the old scheme referred to.
You're trying to have your cake and eat it because you want a broad discretion, but you want to exclude a lot of what on the face of it appear to be very highly relevant factors.
Well, yes and no. What I ask for is that the discretion implicit in Section 32(2)(a) is the starting point. Once you have got past the starting point, well, first of all, you need to decide whether or not to impose a penalty. And there are matters that one can pray and aid in support or against the proposition whether there ought to be a penalty or not. Once you've got past that stage and the court has determined there ought to be a penalty, then the matters under Section 33 and the Code of Practice and the other matters which ought to be taken into consideration come into play as to level of penalty, which is why it's known as the level of penalty Code of Practice. I say that that's not a sufficient Code of Practice, and I've made my submissions on that already. But with the greatest of respect, if the scheme says Section 32 impose or not, and then if impose, then go on to whether or not there can be reductions, that's the way in which it ought to be approached by the courts below and by the Secretary of State. Is the submission.
So just to be clear, you say, well, the judge was mistaken in thinking that there was a breach of 2E2.
Yep.
In fact, there was full compliance. Yep. Under the Code of Practice, that would get us a 50% reduction to £18,000.
Yep.
But court, you ought to go further. Now you say, looking at matters in the round under Section 32 and then Section 35A, it's open to this court to say no penalty at all.
Yes.
And you say that that's what we should do. If we weren't persuaded of that, is it really, as on your case, 0 or 18,000 or is there any other position?
No, there is another position, and that other position is provided if you are to be bound by the Code of Practice, which says that the Secretary of State may take into account other matters such as they think relevant. The statute also says that. There are other matters that you can take into account which you consider to be relevant. And the primary one I would urge upon you here is it has been said repeatedly that the case I faced below, when one put aside much of what went on this morning, was the case that's now being advanced, that I was in breach of section 2 of paragraph 2, regulation 2E2, because there was no record made of the pre-journey checks. Well, with the greatest of respect, that was not the case I had to answer below. That was not the case I knew I had to answer today. And indeed, this morning, the case I had to answer today was a very different case. And so when I go to the court below and advance a case run on the basis which goes, I don't actually know which regulation you say I've breached. I say I haven't breached any regulations at all. And then I'm faced with a very, very much a movable feast when I get to the Court of Appeal. I say that's rather exceptional, because even now, I'm not entirely convinced that I know the case I actually face because of the way in which matters have been put today. And I think your lordships can take account of that in determining whatever, if there is to be a penalty, what the appropriate penalty is to be. And on the issue of discretion, if I might,
Yes.
whilst I take on board what my lords say about the judge's other findings, i.e. insufficient
81.
training, etc., I do say this: it is not entirely beyond the realms of sensibility that the judge, having concluded that there was a breach of section of regulation 2E2 for the reasons he did, that his exercise of a discretion was in large part, if not entirely, informed by that rather substantive finding.
And they're not completely separate, are they? Right?
They're not completely separate,
Because-
but in the language of the judge, a substantial breach of
Yeah.
the regulations.
And the training point, both in paragraph 81 and in the last couple of paragraphs, is very much an add-on, isn't it?
Could I also add this about the case I faced below? It was said that the case I ought always to have faced was that which is now advanced, which is that I was in breach of the failure to record the pre-journey actions. Can I take my lords, please, to the transcript of the judge's ruling, which appears starts at page 93.
Judgment.
Oh, the judgment, yes, forgive me.
First.
It's page 93, yes.
First
Instance, yes.
We're in the first judgment.
Yes.
There are two judgments.
Yes, the second is Judge Coe's, which I put there for interest's sake. I'm looking at page 93 because the earlier one it related to a matter which is not, we're not concerned with about whether a statement was properly formatted. But I'm looking at page 93. No?
93
Of the core bundle.
is the judgment of Judge Owen.
Yes, that's what I'm looking at.
Yes, but that's his first judgment on admissibility, isn't it?
Well, yes, but it then goes on to deal
Yes.
with. That's. I'm just saying that's where it starts. But the page I want to take you to.
That's
is
what I
one-
meant by the first judgment.
Yes.
And his
forgive
second
me.
judgment was the
Yeah.
second judgment,
Yeah.
not Judge Coe's judgment.
No, not Judge.
Okay.
No, sorry. Page 9. It's been a long day. Page 99 is the page I want to take my lords to. Paragraph 38. It said that the case I always faced was a failure to record the pre-journey checks.
Yeah, the Bologna recording.
Yeah. Well, I'm afraid Judge Owen says this at 38. The conclusion was that the owner or hirer did not fully comply with Regulation 2E2 of the 2023 regulations. It was noted in the conclusion that the checklist provided on the day of the incident shows no checks within 24 hours of the incident. That was the allegation which the owner was said to have been in breach of. It is not the case I face today. And it goes on. paragraph 76. And here's the only other paragraph I should take my lords to. Firstly, having regard to the facts as they appear to me to be, they are as follows. I am satisfied there has been a breach by the first appellant of Regulation 2E2 as specified in the IS 11 penalty notice in this case.
Yeah.
It is not the allegation I now face, which I've only learned of today.
And then something goes wrong with the sentence, doesn't it?
Well, yes, it does, but that may be the transcriber.
But then the odd thing is, he does refer to 2B2356.
Just so.
He's read out what's in the
Yes, of course he has.
IS 11.
Just so.
I know, but it doesn't look as though much thought's gone into it.
Well, I'm not going to make any comment on that, but but I would say this. This is not the case that I've had to face today, this afternoon. It wasn't the case I had to face this morning. And that really encapsulates my real difficulty here today. And I say you can take those matters into account when dealing with issues of discretion. But I also take you to those points for one other reason, and it's this. And it's when I rather rudely interrupted my learned friend and my lord said, sit down. It has been said on a number of occasions, quote, not raised by the appellant in the appeal, quote, the matters could have been asked of Mr. Mills in cross-examination, quote, that point was not taken below. Well, of course, none of those points were taken below or taken up with Mr. Mills, because the case that is put against us today was not the case that was put against us below. And so how were we to know what issues we were to deal with and what cross-examination would have been appropriate?
Would you forgive me to go back, if I go back to paragraph 81, which is on the discretion point? I just want to develop the point. They're not discrete because the training deficiency highlighted by the judge related specifically to record keeping. Isn't it?
I beg your pardon?
The paragraph 81, he says, where he brings in the training, the complaint about inadequate training for the driver.
Yeah.
Which I know you say is old hat, but if he, insofar as he does rely on it, it seems to be particularly focused to not giving him instructions about his duties as to record keeping.
Well,
what's the other thing?
Mr. Nestiano's witness statement contains some generalised assertions about training and instruction by the company. No specific evidence within his statements about what, if any, training and instruction was provided. I accept the judge's finding of fact, as I'm bound to, but I submit that it doesn't go so far as to warrant the exercise of discretion in the way in which it was exercised.
He then goes on to say his failure to complete the checklist in fact suggests he'd not been properly trained or instructed as to his duties, but it's slightly divorced from reality, isn't it? Because what everybody is now assuming is that this was a complete fraud by the driver.
Well, it was. It clearly was.
And in which case, whatever instruction your client had given him would have no effect.
Well, this is one of the points I'm making in my skeleton argument, if I may, which is to the effect of how can you blame the owner-hirer for the driver's misconduct in such circumstances? And I was going to develop it earlier when we got into a tussle about vicarious liability, etc., and then we moved away from that proposition.
To be fair, there is a point there that doesn't depend on the driver's fraud. However you look at it, the driver had an obligation to, on his part,
Yes.
to keep the checklist up to date, and he didn't.
Yes.
So I suppose that provides a basis for the judge's inference that he hadn't been told to do it. Now you may say, well, that's not a very strong basis, but
Except that we now know that the driver took the checklist he provided to Border Force, to Officer Mills, and between that point and handing it into his employer, he took every step to make it look as if it were a properly completed checklist, which rather suggests the stronger inference that he knew full well what was required of him.
I'm not entirely following that. I mean, fact that he filled it in late doesn't mean it was fraudulent.
Well, we know it was fraudulent because he admitted it to his employer. That's why the appeal in respect of him was abandoned. But the point I make the point for this reason, not for that one, but for the reason that it suggested that on the training issue, it's possible that he hadn't been properly trained or instructed. And my counter argument to that proposition is, well, he clearly had, because he knew how to fill it in to make it look as though it was properly completed. And therefore, somebody at some point had told him what was required of him.
Can I just be clear about one point? Assuming we get this far and have to think about what we do as opposed to being bound by what the judge. I don't imagine anybody wants us to send it back to the judge for him to have another go at it.
No.
And I assume that's the Secretary of State's position too. Yes.
Yeah, thank you. Those, my lords, are my submissions unless there are any questions for me.
Mr. Howard.
My lord, I apologise for him. Beg your leave just to make a few factual corrections about whether or not the argument raised this afternoon was raised in the lower courts. The point about the checklist and about the evidence of the checklist was raised in the skeleton argument at the first appeal. That's page 73, paragraph 36.
Sorry, 73 of what?
73 of the trial bundle, from the first appeal trial bundle, paragraph 36. It clearly states the first security check was completed the day after loading. No further standard checks were completed. The incident took place more than 24
Sorry,
hours.
can we keep up with you? And Mr. Clark must have the last word. But
course,
so we're
it's
on
just to
page
correct the factual error.
73 of the supplemental bundle.
It's for your consideration. I don't have to go through it, of course, but it's just the point that was raised. Page 73, trial bundle, paragraph 36. That's when it was alluded to. But in terms of the actual submissions, it's on the transcript with His Honour Judge Owens at page 73, and it's the very, very top
73 in
the appeal bundle. So the point being, it was raised with the lower court as to the checklist. So the case which was raised on behalf of the Secretary after the non-standard adjournment was before the first appeal.
Sorry, I'm not keeping up to I see. So we're in the transcript.
Yes.
And where are we now in the transcript?
Just the very top, page 73, and you can see the submissions made. It's made collectively about, the point is said vicarious liability, but it's more about if there's a failure on behalf of the driver, that the company's liable, etc., as has been the submissions before the court today, this afternoon. But it's the point being made that it wasn't raised in the lower court about the checklist or otherwise. It was within the skeleton argument and indeed before the first appeal.
Can we just
That's all
read
it
that
was.
through then? Or perhaps I'll just
Where
read.
do you want us to read? From the top of 73?
Yes, it's simply it's highlighted in those two sort of transcripts of what my submissions were, about the falsification of the checklist or otherwise. Because obviously it's not correct to say that wasn't raised.
Yeah, I mean,
that's all it was. Sorry, it's the appeal bundle of the transcript with His Honour Judge Owens, page 73.
So you specifically rely on the fact it says, you say, there are only checks done the day before the stop, not on the day, not on 2 days previously.
Yes. And that's the relevance as to 2E2.
And there you're relying also on the skeleton at page 73 in the supplemental bundle.
36. So what you've seen in the appeal bundle is the amplification of the submissions, obviously on paper, but there is mistakes within that skeleton argument, mainly the reliance on the defence under section 34.
Does 36 really deal with the point? I see the point about the 2 days in the transcript, but here it isn't really separating out the last 24 hours from what came earlier, is it?
So the point to rely on, it says, in summary, the evidence demonstrates that the appellant driver had left the vehicle on security point during the journey. Further, he had not completed robust checks or fully completed security checklist. Then it describes the checklist, and the first security checklist was completed the day after loading, because of course on the paperwork was the 21st, and the only reference within the security checklist in submissions on paper and in all submissions was that of the 22nd, which goes to the Secretary of State's point that there's been a breach of 2E2. So that was raised in the first before the is only Judge Owens. So that's simply the point I
Yes, I
seek to correct. I'm grateful.
Mr. Clark, you're definitely entitled to the last word on
Well,
that.
I'm afraid that I'm not going to respond. The point eludes me, I'm afraid. Can I have my costs if I'm successful, please?
Well, we're not going to deal with costs now.
No, you're not, but I need to raise it to make sure it's raised. I have no doubt my line of friend would say the same thing given the
Yes, I
opportunity.
shall say. Let me just check if there are any more questions. No, in which case, thank you both very much for steering us through the complications. We won't give a judgment now. It will be reserved and it will be supplied to you in draft before it's handed down. It will be handed down remotely. At the stage at which it's sent to you in draft, we'd be grateful if you would pick up errors in our typing and English. It won't, of course, be an occasion to re-argue the case. You will have in mind, I'm sure, the importance that this court attaches to compliance with the embargo at the stage at which the draft judgment is sent out. If there is anyone of whom we have not already been notified who you at that stage think should see the draft judgment, you need, of course, to come back to us.
Of course.
We'd be grateful too if, once you've got the draft judgment, you'd seek to agree an order dealing with any consequential matters. If there are points on which you disagree, could we please have brief written submissions, and we would expect to deal with the points in the order that we make. But thank you both again.
Can I just add,
Yes.
forgive me, one thing, and you may regard it as quite important. Milona Frand doesn't know what I'm going to say, but he'll agree with it, I'm sure. In timetabling, there are, by my instructing solicitors count, they are instructed in 41 appeals, all adjourned below, awaiting my Lord's decision.
We will have that in mind. No promises, I'm afraid.
I don't seek one, I just thought you ought to know.
Yes.
And my lords, can I thank you for the indulgence of this somewhat change of goalposts after lunchtime adjournment? I do apologise.
Yeah, well, I'm glad we've got to the bottom
Yes,
of it.
I'm
Thank you
grateful.
very
Thank
much.
you. I'll do my learned friend, of course.